Great. Looks like we have folks from all over. Thank y'all for being here today. So my name is Lacey Hensley, and I'm the director of the Institute for Coordinated Community Response. We are a program of the Conference on Crimes Against Women. And so before we get started, just a few housekeeping items. We encourage you to use the Q&A box to ask any questions throughout today's presentation, and I will assist our speaker today in monitoring those and getting those questions answered for you. We also invite you to use the chat feature to provide comments and interact with other attendees. And if you have any technical difficulties, you'll select the host and panelist option, and I will try to assist you with that. So a little bit about ICCR before we begin. ICCR was created in 2018 as a program of the Conference on Crimes Against Women. We're a training and technical assistance program whose mission is to work alongside rural communities to improve their collaborative systemic response to domestic violence. We do host monthly trainings like the webinars, like the one you see here today. And while we're geared towards the needs of all rural practitioners, anyone can get great information. I'm tongue-tied today. In all of our trainings, we work to center the unique needs of rural communities, but provide practical skills for urban and suburban communities as well. So you can learn more about us at on our website, instituteccr.org. I encourage you to sign up for our e-blast to stay in the loop of all the great trainings that we provide throughout the year, including our 2-day virtual conference that we have in October. It's a great 2 days of virtual content for the low price of $100, or a group rate is even cheaper than that. So today we have a longtime friend of ICCR, John Gard. John is the Chief Deputy with Pitt County Sheriff's Office in Greenville, North Carolina. He has over 30 years of law enforcement experience, including line level response, investigative response, first and second level supervision, and agency management. For almost 2.5 decades, he specialized in investigating domestic violence cases. He's been instrumental in developing policies and procedures related to domestic violence response in Pitt County and the state of North Carolina. Throughout his career, Chief Gard has trained law enforcement officers and other allied professionals in the dynamics and nuances of domestic violence from both a law enforcement and a social justice perspective, worked with victims as a law enforcement officer and as a victim advocate, and provided information to community members regarding domestic violence. He's developed and implemented several innovative programs designed to increase victim safety and offender accountability, and many of these have been replicated throughout the U.S. Chief Gard has received numerous awards for his efforts related to DV prevention. So he's a longtime friend of ICCR and has presented for us many times at the Conference on Crimes Against Women, and will be presenting with us again this May. So John, are you there? Turn on your camera there. All right, I'm going to stop sharing and let you take it away.
Okay, and let me get back to sharing real quick. Lacey, how can I go back and share my screen here?
Should be at the bottom of your screen there because you're a co-host.
Okay, can you see the screen and hear me okay?
I hear you. I don't see your PowerPoint. There you go. I see it now.
Okay, thanks for bearing with me, everybody. Lacey, thanks for the great introduction. As Lacey said, my name is John Gard. I'm currently Chief Deputy, Pitt County Sheriff's Office in Greenville, North Carolina. We're kind of somewhat towards the East Coast, towards the Outer Banks, but probably a better description would be halfway between our state capital, Raleigh, and the Outer Banks of North Carolina. So I've just entered my 32nd year in the business. And as Lacey mentioned in the intro, A lot of work done surrounding domestic violence and intimate partner violence over the course of my career. One of the things that I've come across and worked towards, not only locally but nationally, is dealing with the with firearms in the context of domestic violence. So, without further ado, I'm going to go ahead and jump into some of the learning objectives that we'll be covering today. We're going to look at the need to address firearm possession in the context of intimate partner violence. And you'll hear me throughout the 90 minutes interchanging domestic violence and intimate partner violence. Recognize the various U.S. codes that prohibit the possession of firearms and allow for their lawful seizure, and then describe the benefits of implementing policy and training that governs the investigation of firearm-related crimes. So, we have the chat up there. I'm going to start with just a question to the group, if you don't mind. And again, this is going to come from a law enforcement or criminal justice perspective. It certainly would be beneficial, or is beneficial, to advocates and other members that float under the criminal justice umbrella. But with this in mind today, and this kind of helps me in my delivery of the content today, what would be your biggest frustration regarding domestic violence and firearms in your current professional placement? If you could pop some of those in the chats, I'd appreciate it. That would kind of help me in my delivery as we go further. Okay, orders of protection not being followed. Relinquishment. Okay. Okay, so a lot around confiscation or people relinquishing possession. Okay. All right, good. Thanks for everybody that's participating. First, before I jump into the content of the presentation today, let me just say this again. Cop with 32 years. I'm not anti-gun, but I am certainly anti-bad folks having guns. I'm all about, why I got into this profession is upholding the law, and holding offenders to account for bad acts. So a lot of great information y'all are placing into the chat, and I'm going to touch on the overwhelming majority of them. But before I do, I want to start by sharing some of my personal frustrations in dealing with this. And that'll be this. I'm going to start with a video. It's a 1-minute video clip from an interview with John Stewart and David Chipman that captures a couple of my frustrations. David spent 25 years as a special agent with the Bureau of Alcohol, Tobacco, and Firearms, better known as ATF. He most recently was a nominee to serve as director for the ATF under the Biden administration. However, his nomination was withdrawn, which, just a little side note, that's happened repeatedly in that position between 2006 and 22. So, but at any rate, this video kind of touches on some of my personal frustrations. So I'm going to play that now. Now, some of the volume is, I wouldn't say hit or miss, but maybe low. You may have to adjust your speakers on your computer as I'm playing these. I may have 3 or 4 in the presentation today. So here we go.
So many of the homicides in this country actually stem from domestic violence cases. In fact, so many of the police shootings in this country stem from domestic violence.
Yes,
Is that a place to start?
certainly domestic violence is a place that we can do better. And we do have laws on the books.
The federal law is that if you have a protection order or you have a restraining order, or you've been convicted of domestic violence, you cannot own a firearm.
True, or ammunition.
Or ammunition. But there doesn't seem to be a dissemination of that into local and state level enforcement.
Every year, over 10,000 Americans go into a licensed gun dealer and they lie on the federal form, committing a federal felony that will put them in jail for 5 years because they've already been convicted of a misdemeanor crime of domestic violence, or they're currently on a restraining order. No one does anything.
How many people?
Over 10,000 a year.
And throughout the 90 minutes today, I'm going to weave in some of the complexities and reasons behind this. I think everybody attending today will pick up some good information. And that's my hope. And certainly we're here to help you going forward. But here's the good news. Domestic violence homicides can be reduced. A weapon seizure policy is certainly a strong one, part of a coordinated community response. Even if your statute, and we have people from all over the country that have joined in, didn't catch every state, but I know it's not just folks from Texas. And you can do this with inadequate resources. And I'll give you kind of a history of what we've done in Pitt County since, say, the late 90s to date, and how that's helped us locally. And you can do all this and still keep your house. I'm referring to law enforcement liability. What's the bad news? This isn't an infomercial. There's issues and there's struggle. So here's some that we hear. We're right here in the middle, specifically referring to law enforcement. We're trying to juggle victim safety, lethality assessments, trying to predict the future of what will happen. We have to know not only state law, federal law, constitutional rights, policies, and our own leadership internally, and balance all that out, trying to prevent any civil liability coming into us as individual allied professionals or to the agencies we work with. So I get that there are certain breakdowns within the system that doesn't allow for sharing of a lot of information. I'm going to try to condense a good amount today and keep the message very simple. Keeping guns out of the hands of people who commit violent crimes is a good thing. And I realize, because we're so diverse on the people that are here today in the states you're from, every state varies to some degree on how they address the purchase and or possession of firearms. And just to give you an example, up until last year, you had to have a purchase permit to purchase a pistol in North Carolina. We have a concealed carry program very similar to what Texas has. Now, that has changed. We no longer are a permit state, whereas all the permits run through a check, but the background check is done by NICS up in Clarksburg, West Virginia. Furthermore, every state represented here today's laws vary as far as the restriction of firearm possession to certain individuals that they serve, and their criminal penalties upon conviction are different. Today's presentation is going to focus on a few, not all, but a few of the federal laws that could be beneficial to agencies and officers around the country to prevent prohibited individuals from possessing firearms. So this presentation is meant to supplement, not replace, but supplement your own state statutes you have within your individual jurisdictions. And I know all the attendees are very familiar with their state statutes. I want to start by the case that happened towards the end of last year. It was on Sunday, November 19th of 2023. Officers responded to 3 shootings in Memphis. About 5:34 p.m., they arrived on a residential street to find the bodies of 2 women as well as an injured teen in what investigators suspect was a domestic violence related attack. And this comes from an article about this homicide, these murders. About an hour later, approximately 6:40, Memphis police responded to a second scene about 7 miles away, where they found a third woman shot dead. Later that night at about 9:22, police arrived at the third scene about 11 miles from the second shooting, where they found the body of a 5th victim. Police found the body of Mavis Christensen, 52, with an apparent self-inflicted gunshot wound after he had targeted 3 women and 2 teenage girls, all of whom were related to him. So again, a lot of different ties to domestic violence and homicide and even mass shootings. And I'll share some of that research with you as we go through today. I want to give you some basic numbers real quick on firearms and intimate partner violence. And these have been published. You're going to see some of them are older statistics, some are newer, but there's no doubt it's been increasing in recent years. The presence of the firearm substantially increases intimate partner homicide. Recently, more intimate partner homicides committed with firearms than with all other weapons combined. Nearly 2/3 of women who experience intimate partner violence with a firearm report their abuser used the firearm to threaten, scare, or otherwise harm them. Male abusers have reported that they use firearms to intimidate their abusers. We can go on and on and on, and there's just so much data out there that says this is just a bad mixture. But not only for families, it's lethal for cops. In 2017, according to the National Law Enforcement Officers Memorial Fund, more officers were shot responding to domestic violence than any other firearm-related fatality. Between 1988 and 2016, 136 officers were killed while responding to domestic disturbances. Between the same time, 80 were killed in a drug-related arrest. So I'm not minimizing those officers that were killed in something that was narcotics related. I'm just saying, if you're looking at the numbers are what the numbers are. See here, in 2014, number of officers killed in line of duty increased 56%, 56% in 1 year. And all you have to do, and I read these articles and get notifications all the time of officers that are killed in the line of duty. Just so many times there's a tie to domestic violence or intimate partner violence. So this is one of many reasons we have changed the way we've done business over the past couple of decades in our jurisdiction. If you look at Newtown, the mass shooting there where 26 people were killed, everybody's aware of that case. It is a good example of how domestic violence comes into the area of mass shootings. But what you may not know is the Washington Post did a follow-up article a year after Newtown, and what they found in this was that it's not only adults. 52% of the kids that were killed across the country in 2012 were killed in the context of domestic violence. So at this point, you may ask what can be done. Well, I've shared some statistics with you, and I've shared a video already. I'm going to share another one real quick. It's a 3-minute video clip, again, with John Stewart. It kind of sums up the need and even gives you more statistics in a quicker amount of time than I can. So here we go.
We obviously can't agree on who the good guys are, and we can't seem to agree on who the bad guys are. So what are we supposed to do here? Not a sci-fi Tom Cruise movie where we have some magical premonition of which bad guys are about to commit a violent crime and can intervene in the crime before it's too late. Or is it?
It appears a domestic dispute led to the massive at a Texas church that left at least 26 people dead. The gunman, Devin Kelly, had a history of domestic violence. The GOP shooting at the baseball diamond. He had a history of domestic violence, reports of domestic abuse, domestic violence complaints against him, and an allegation of domestic violence. History of domestic violence.
6 arrests for domestic violence.
20 years old and already has a domestic violence history.
Domestic violence offenders. It turns out domestic violence is a predictor for gun violence. In fact, there's a study that suggests a felony domestic violence conviction is the single greatest predictor of future violent crime among men. This is our sci-fi movie fix. Because if we simply kept guns away from domestic violence offenders, we could potentially stop 60% of mass shootings, 30% of child firearm deaths, more than 50% of women, 65%, 75%. Okay, I'm sorry. Load. Every 14 hours, an American woman is shot dead by an intimate partner. You might not care about any of that. And if you're the type of person who doesn't care about any of that, I do think I know an area that may speak to you more.
2 police officers shot and killed responding to a domestic violence call.
A rookie police officer was gunned down responding to a domestic violence call.
Shot and killed early this morning, responding to a domestic violence call.
Shot and killed while responding to a domestic violence call.
Responding to a domestic violence call.
Shot and killed in the line of duty. They were reportedly responding to a domestic violence call.
It turns out removing guns from domestic violence offenders also backs the blue. Between 2015 and 2016, domestic dispute calls made up 41% of all fatal police calls. For police, domestic violence calls are the single most dangerous calls that they respond to. That's why we let these wife-beating cop killers get away with literal mass murder. By the way, the law already says domestic violence offenders can't have guns. If we just enforced that law, we would prevent other types of gun violence, the kind that actually makes the news. It's not a solution, but it's a real harm reduction model for gun violence.
I really like the way John Stewart summed that up, and he's absolutely correct. As law enforcement, here are some things we can do. We certainly have the ability to remove guns from the possession of people who commit violent crimes. Just like we have the ability to seize controlled substance in the narcotics investigations. So there are ways to go about this. Before I delve into the particulars of the federal law, I want to take an opportunity to kind of share some history here in our community and how we've evolved over the years. Again, no federal firearms training in the academy. This was based on a lot of trial and error. How we started this was based on our knowledge of the North Carolina law at the time and how we started making some inroads in this, excuse me. Sorry about that, guys. I do not know how to turn that off. So here's our journey. This is how it all began. So we have what is known as ex parte domestic violence protective orders, just like your order of protections you have in your state. Ex parte, Latin word meaning hearing of one person, one side. So in these orders, like a lot, it directed defendants not to possess or purchase a firearm for the duration of the order. And I'll show you a picture of ours that may look a little different, but the substance of these orders are pretty much the same from state to state, jurisdiction to jurisdiction. And here's what I'm referring to, that common language, which you see in most states. The defendant is prohibited from possessing a firearm for the effective period of this order. And in our case, back then, their handgun permit or purchase permit was suspended for the effective period of the order. So when I came to work here, I started at a municipal agency in the very, very early 90s and made the transition in the mid 90s over to the sheriff's office. So we didn't, by daily ops as a municipal officer, deal with the civil protective orders, the ex parte orders. So when I came over and made the transition, I was in field training, and we would look at the ex parte, saying defendants are not to possess or purchase a firearm for the effective period of this order, as you saw in the previous slide. And I remember in field training, I didn't say a whole lot, but I would see officers seizing the firearms at that point in time. And although I was a rookie to the agency, I understood the Fourth Amendment pretty well, and I felt a little uneasy about that. You know, I felt that was a questionable practice because you're dealing with a seizure of property, minus consent, probable cause. So it was tough. You know, I looked at it and I said, you know, I really have an issue with this. I applaud the effort, but I really thought you're hinging on what potentially could be labeled as an illegal seizure. And for those on the call today or on the Zoom, when we look at constitutional issues, specifically the Bill of Rights and the Fourth Amendment dealing with search and seizure, everyone has the right to be secure in their person's own papers and effect against unreasonable searches and seizures, and it shall not be violated. So everything hinges upon legality and what we need to do. So officers across the country are very well versed in the Fourth Amendment. Hence why I felt a little uncomfortable with the seizures back then when I was in field training. So we kind of backed off that. we went later away from just seizing based on that, and we said, okay, well, they can't have it. What are we going to do? Well, we'll get a friend, a family member, and we'll just have them transfer the firearm uh, to another individual. And then that way, when we cleared the scene, the order was served, they were not possessing a gun. Well, several problems here with that. One is we didn't run a record check of the third party we were transferring the firearm to. Once the deputy left, what do you think happened? More than most likely, it went back to the person that was prohibited. So in a nutshell, there was really no true effort made to ensure that the law kept its promise. So after my field training, some time went by and I was actually promoted to run our domestic violence prevention units created January 1st, 1997. And one of my first orders of business said, hey, we're not going to do this anymore. One, we're not going to do illegal seizures. And we still have some holes in this thing about transferring. I was really worried about firearms facilitated by us, a transfer facilitated by law enforcement to individuals that were federally prohibited. So I know locally our advocates were really excited to have a unit that was dedicated to work domestic violence cases. And it was rah, 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 all's great. And then we made that decision, or I did, just to make sure we're compliant with the Fourth Amendment. So quick story, our advocates went and spoke with our judges and said, this is what Sergeant Guard is doing. Now he stopped seizing the firearms. And the judge agreed with me in their conversation that you've got a Fourth Amendment issue. Luckily, we have really, really, really smart advocates here locally within our community. And they said, okay, what else could be done? And the judge said, well, we can help you with that. You can have firearms surrendered, and we can do it by the ex parte. So how do we go about doing it? I'm going to show you the same copy of that same order I showed you earlier. If you look right here under number 15, and this happens across the country in jurisdictions, you have an other block that's blank. And our judges, each and every one of them, started handwriting in on the order. And you got to think about this. This takes effort. The agency serving this order is to immediately seize from the possession of the defendant all firearms and other dangerous or deadly weapons. For me, that certainly takes care of our Fourth Amendment issue. Again, does this give me a right to go in somebody's home without probable cause? No, it doesn't, but it certainly gives me the right to take the property. So, how it works. And again, this all comes through trial and error and learning things. With increased knowledge comes increased success. Success is certainly based on the delivery by the person serving the order. In other words, if I pulled up on a scene, made contact with the defendant of the order who is to be served, and I read the order one by one, each thing that's ordered, and it says the agency serving this order shall immediately seize from the possession of the defendant any and all firearms and other dangerous or deadly weapons. If I read that to them and then say, do you have any guns? They're going to say no, right? So we learned how to change that delivery. Not only that, when we changed our delivery, we were able to obtain more firearms, and we would document those seizures through a written report that's housed internally within our record management system, and we give them a receipt for the firearms. So we had knowledge, we knew today, again, here's how we changed it. Delivery was, instead of reading the order and saying, do you have any guns? We'll redo it. Roll up on the scene. There's the defendant. Confirm the identity. Hey, bud, don't run off. I don't have a warrant. All I got is a civil paper, an order of protection. I'll be in and out of your hair in about 5 minutes. Real quick, a big on officer safety. How many guns do you have and where are they at? With that change of delivery, the numbers of firearms that were surrendered increased significantly. So that works the first time. We're going to talk about recidivism. Pitt County, I know, is not any different than any other jurisdiction around the country. You have super high recidivism rates when we're dealing with domestic or intimate partner violence. So that change in delivery will work the first time. But what happens 3, 6, 8 months later after the order has been dismissed? They got the firearms back and we go back to the hunt. I can do that same delivery. Hey, don't run off. I don't have a warrant. You're not under arrest, civil paper. I'll be out of here in 5 minutes. How many guns do you have and where are they at? I'm gonna tell you what they're gonna say. I don't have any guns. And we go, hey, partner, I've got a report from 3 or 6 months ago that says we seized 5 firearms, or you surrendered 5 firearms, 3 of which were pistols, 2 were long guns, shotguns or rifles. Where are those guns? And they're gonna say, because it's not their first rodeo, I sold my pistols. Well, fortunately, again, this goes back to knowledge is power. In North Carolina, we had a state statute that said you could not transfer, sell any pistol to anyone in the state of North Carolina without a pistol permit. So when we asked him about those 3 pistols, he either had to give me a permit or the firearms. So he or she's in a quandary at that point in time. Now, I recognize that all the states represented will not have this statute. You may not, but this was our workaround, and it evolved based on our knowledge of the current state law. So everything's different. So that's how we were to facilitate. It's been my experience, the overwhelming majority, and I'll show you some research here in just a minute on the numbers. The overwhelming majority of people who own firearms that are subject to a protective order are willing to give up the guns. So long as they understand the process and they know we're not going to damage them or anything like that, they're just more apt to do it. And that's what we found. I'll share those numbers with you. This is just a short snapshot, but August of 21 to November 22, the Pitt County Sheriff's Office seized or received a surrender of 437 firearms. That's across the agency for every type of call, every type of crime there is. The members of the domestic violence unit actually received or seized 313 of those 437 firearms. So just from a mathematical perspective, 72% of all the firearms that come into the agency during that point in time were received by 6% of our sworn staff. So I get we're all busy, but it's all about how you work this efficiency, your delivery. And I know storage is a thing. I mean, here's a picture of our storage room at one time. If you look up in the upper right-hand corner, that's a dehumidifier. We actually take better care of their firearms than most individuals do. So it's not onesies or twosies. There's a lot. And speaking of onesies and twosies, this is an officer safety thing and really a knowledge thing for everybody else on with us on the presentation today. Average number of firearms, and everywhere I go and everybody I talk to, everybody says we all have guns. There's a lot of guns. Well, we're no different than anybody else. The average number of firearms seized per person in 2004 for the protective orders was 7. And if you're thinking we did a seizure of 200 from one individual and that threw off our numbers, no, it wasn't. The highest we seized in that same time period in 2004 was 26. So the data's old, but you can see where we're going with it. Everybody who has guns, typically, if they have one, it's not just one. They have multiple, has been our experience. So just how we work things. So what happened? And again, a lot of talking about history and specific to Pitt County, but the gist of this part of the presentation is saying, look, everybody's laws are unique. There are certain areas you can leverage to start with if you choose to. So what happened from that in Pitt County? Well, eventually, word got out across the state of what we were doing in our district. And our policy and practice became state law. Now, timing had a lot to do with this, but it's Senate Bill 919. It was in 2003. It was titled the Homicide Prevention Act. And I'll talk about kind of the timeline and why this may have happened. Back around then, one of the largest newspapers in North Carolina did a feature on domestic violence, the number of people who were killed and how we as the criminal justice system was lagging behind. And you know, we needed to do different. And I'm telling you, it was a multi-day series, above the fold, every day, color article or color pictures with a ton of substance, talking about just how far behind North Carolina was addressing domestic violence. And at the time that 4-day series ran was the same time that the Senate Bill 919 went to the legislature. And it was a lot of support. You know, across both sides of the aisle. And it's the way we interpreted the belief of the communities we're serving across the state was people like me did not want bad folks that are prohibited from possessing guns to have guns. So there was a lot with it, and I'll play a quick video here and kind of show you some of the what was being shared across the state concerning this statute as it was going before the legislature.
Fists, knives, even words. But law enforcement cites guns as the biggest killer. The Homicide Prevention Act seeks to diffuse gun crimes in these cases, but according to some groups, the bill itself could be used against an innocent person. Law enforcement in Pitt County found an effective weapon against domestic violence, one that could be used across the state.
This is a tool. It's not foolproof, but it's another tool that our officers can use to help, again, break that cycle of violence.
Sheriff Mac Manning and his department remove guns, all guns, from the hands of domestic violence offenders in certain situations when a judge orders the weapon seized.
When a perpetrator has either used a firearm or weapon or threatened the use of a weapon in a domestic violence situation, obviously it's prudent practice to take the weapons out of that person's hands. And I think that's common sense.
It just may be the key to reducing domestic violence deaths. As the number of guns in the Pitt County evidence room has gone up, the number of homicides has gone down, where the sheriff has jurisdiction. In fact, since taking this tool to the streets, no one in Pitt County outside city limits has been killed in a domestic violence situation where law enforcement were involved.
So just a little snapshot giving what was going out around the state as that bill was navigating the legislature. But at any rate, it did pass. It passed unanimously. And as you'll see here, the language we had, or a version of the language we had under other in 15, moved to 13. It says the defendant orders the defendant to surrender to the sheriff serving the order the firearms, ammunition, and gun permits described in number 3. So our policy and practice became state law. They still have the section where they're not to possess or purchase, but the remedy for the Fourth Amendment issue for it to expand was fixed on number 13. So that's kind of how it come about. And you know, did it stop everyone from waving guns at their wives, ex-wives, girlfriends, or ex-girlfriends? No, it didn't. But we did move the ball forward a little bit. And I will say what they said in there, when we implemented that, we hadn't lost anyone in our county jurisdiction. In fact, just a little side note, to date, since we started our unit, January 1997, we just lost last year the second victim we had ever touched. So 2. And the correlation with both of those, just so you're aware, is both were murder-suicides, both with firearms, and both the offenders were former officers. So just a little side note there. So we already know nationally that 42 states prohibit most abusers subject to a protective order from purchasing or possessing firearms. That's within their state statute. Restrictions that prohibit domestic violence protective order respondents from purchasing or possessing a gun has a positive impact on intimate partner homicide. In fact, there's 17% reduction in firearm homicides along with female intimate partner victims. Again, a lot of this is because of the restrictions. Now, that being said, there are enforcement gaps in the protective orders that undermine its effectiveness. So we also know that 27% of defendants known to have a firearm were willing to surrender it when they were served the order. So again, peer-reviewed data out there. So currently, 18 USC, United States Code 922 provides a number of federal prohibitions to lawful firearm possession within its various subsections, and there's a lot of them. So I'm going to give you some of the big ones, big U.S. codes that you'll see more often than not in DV or intimate partner homicide or intimate partner violence investigations, and we're going to talk about how you can leverage those. Again, going back to the Constitution and the Bill of Rights, just need to repeat it again. You know, we know the Fourth Amendment as far as those of us in law enforcement, we work within its protections every day. So it's not new to us. Everything I share today is meant to work within those protections set forth in the Fourth Amendment. Simply put, firearm investigations are just like any other investigation, be it robbery, rape, stalking, murder, etc. There are times when an officer will have to obtain a court order and or a search warrant for an investigation that leads to the seizure of firearms, just like we do when we obtain evidence in other crimes we investigate. So this isn't anything different than we do day in, day out. I think a lot of this is two things I found that people in this business hate, and that are the way things are and change. Change is always tough. Furthermore, again, the term firearm I just used was in the singular sense. It's not meant to imply, as you saw with the numbers from Pitt County, the average being 7, that there's only going to be one. In fact, my experience again has been that if it's never just one. More often than not, there are multiple. So not only is that an officer safety issue, but it's an issue when we're trying to ensure the protections offered by protective orders around the country. So what's our authority to seize a firearm when there's not a violation of a state law? And we get this a lot internally, or we did as we're moving forward. So I'll just go back to our oath of office. And under the first sentence up here, I solemnly swear or affirm that I will support and maintain the Constitution and laws of the United States and the Constitution and laws of North Carolina, not inconsistent therewith. So we're signing that, and most oaths of office are very similar. Furthermore, if we look at 18 USC 924D, it authorizes the seizure and forfeiture of firearms and ammunition involved in or used in a violation of a federal criminal law. So again, that's what's out there. But I can tell you, we're looking at 18 USC 924D. That wasn't shared with me in the academy, and I'd be willing to bet $1 to a hole in a donut it's not shared in a lot of other academies either, because it's the federal statute. And typically, you know, and this is one thing that gets us, we all tend to work in silos, and we know what that does when you're working to increase people's safety. It's not a good thing. So we need to share data across disciplines. So how do we do that? How do we increase our knowledge? Well, it's 2014, I believe, if I'm not mistaken. This was the last re-up of the publication for the ATF, which gives you all the federal firearm regulations. Full book, you can download it online. Just go to the ATF, and in fact, I've got it sitting right there in a text box below the ATF's emblem. There, you can download that edition right to your desktop. Again, because the limited amount of time we have in the presentation today, I'm only going to address the few I think are probably most likely to be seen in a partner violence case or a protective order case. But it's got a wealth of different codes in there that absolutely can be leveraged. Now in 18 USC 922, under both G and D subsections, you have multiple other subsections that address these. I'm going to play a video here in just a second that will give us a little more information on this. And I realize, you know, we're talking about federal laws and those silos, that You know, as law enforcement, typically we try to stay in our own lanes. And it's easy to say, hey, there's federal laws. It's the responsibility of the ATF to enforce them. But the reality is there are as many officers in the Las Vegas Police Department than there are ATF agents in the US. And on top of that, and on top of their investigation and enforcement of violations of federal gun laws, they have regulatory oversight of all the federally licensed firearm dealers. In fact, you can Google this. There are more federally licensed gun dealers in this country than there are McDonald's, Burger King's, Subways, and Wendy's combined. So when you think of it like that, uh, they're stretched pretty thin too, just like we are. And, you know, as a shout out to my federal colleagues, I want to play a kind of a quick video to maybe what will capture the impetus for some of the local and state law enforcement's frustration with them. Real quick, and I didn't give the R-rated comment before one of John Stewart's videos where he used some foul language. I apologize for this. There's a little bit in this one too, but it's a good way to kind of break up this presentation for a second. Well, having some technical difficulties, and before y'all jumped online today, we tried to play this and it just, I swiped out for another video, and apparently it's not, the bandwidth isn't keeping up with this, but basically it was just a little gig at my federal colleagues in law enforcement. Whereas sometimes it's been said that locals do a lot of the work and they come in and take the case. I hadn't really found that to be the case, but the way it was delivered in the South Park video that I was going to play for y'all was pretty funny. So we're going to jump in and talk about some of the subsections real quick. 18 USC 922 G9. It's a federal crime to possess a firearm or ammunition after being convicted of a qualifying state misdemeanor crime of domestic violence. So a misdemeanor within your state. The statute applies to everyone to include law enforcement, and I'll go through that a little more. So what is qualifying? Well, to qualify, the charge has to be a misdemeanor under federal or state law. You may not be well versed in the federal side, but you certainly are the state, and that's what we're going to focus on. The misdemeanor has to have an element of the use or attempted use of physical force or threatened use of deadly weapon. The date of conviction must precede the firearm possession. It has to have been committed by people who share these relationships, either current or former spouse, persons who have lived together or have lived together as his spouse, parent, or child, or guardian. They share a child in common, persons similarly situated as a spouse, parent, or guardian. Their current or former dating partner. Now, this is a new prohibition that was just added recently. It lasts for 5 years unless there's another misdemeanor crime of domestic violence. That's when you have a dating partner. And what does dating relationship mean? It has to be a relationship between individuals who have or recently had a continuing serious relationship of a romantic or intimate nature. Whether the relationship constitutes a dating relationship shall be determined based on the consideration of the length of the relationship, nature of the relationship, frequency, and type of interaction between the individuals involved in the relationship. A casual acquaintance or ordinary fraternization in a business or social content does not constitute a dating relationship. Again, these are all things that we would learn through a general investigation and interviews. You're not considered conviction unless they're represented by counsel or waive the right to counsel. If entitled to a jury trial, they had a jury trial or waived their right. So if we have North Carolina people on this, and it may be the same in other states, in North Carolina, misdemeanors are held in the district court. In district court, there are no jury trials. Well, does that mean this wouldn't apply to them? No, because they're not entitled to a jury trial. The way our court system is set up, misdemeanors are in district. You certainly can appeal to Superior Court, which would give you the right to a jury trial, but that's only after it's gone through the district court. if convicted and they had that conviction expunged, set aside, or civil rights restored, then they wouldn't be considered convicted. But in a lot of states, you have a prohibition to having domestic violence convictions expunged. So again, knowing your state law here is critical for that. So in the case of a person who's been convicted of a misdemeanor crime of domestic violence against an individual in a dating relationship, a conviction would not be disabling if it had been expunged or set aside, or the offense for which the person had been pardoned or had firearms rights restored, unless the expungement, pardon, or restoration of rights expressly provides that that person may not ship, transport, or receive. So you have to have that disqualifying language within that order. So if the person has no more than one such conviction and is not otherwise prohibited, the person shall not be disqualified from shipping, transporting, or possessing, receipt, purchase of a firearm if 5 years has elapsed. So again, it's got a 5-year window, and this was new to when they clarified the dating relationship portion. Furthermore, NICS, which is a division of the FBI, it's located in Clarksburg, West Virginia. They should be updated their status within their system for that person. Restoration after 5 years, as described above, is not available for a current or former spouse, parent, or guardian of the victim. So this only applies to those who are in a dating relationship. Now, I want to share something with you real quick. This was the Vinson case, Fourth Circuit, which is the circuit that governs North Carolina. We had a case, and for a time, we were the only state within the country where that that code, 18 USC 922 G9, did not apply. But again, our legislature is called up. They fixed that this year, and this would be for anybody on the Zoom today from North Carolina. They created a new crime, which was misdemeanor crime of domestic violence. Prior to December 1st of 2023, we had assault on a female and simple assault. Because of the way those statutes were written, Vinson overturned us or prohibit us from leveraging that statute to disarm prohibited individuals. But with the new change in the law and the way it's written, Vinson goes out the window. So now North Carolina joins the other 49 states in the country and can leverage that U.S. code. So again, that changed December 1st of last year. So let's move on to possession of firearm while subject to a protective order. It's illegal for a person to possess a firearm while they're subject to a court order that restrains such person from harassing, stalking, or threatening an intimate partner or the child of an intimate partner, or from engaging in other conduct that would place an intimate partner in reasonable fear of bodily injury to a partner or child. To qualify, the order must have these factors. It's got to be issued after a hearing where the respondent or the defendant received actual notice of the hearing and had an opportunity to participate. They don't need to actually appear and attend the hearing for the ban to apply. They just have to have notice. The other element is it restrains the respondent or the defendant from harassing, stalking, or threatening an intimate partner of the respondent or child of the intimate partner or child of the respondent, or engaging in conduct that would place the respondent's intimate partner in fear of bodily injury. Again, intimate partners narrows down and drops off the what some could say is the dating relationship. Okay. It includes a finding. The order must include a finding that the respondent represents a credible threat to the physical safety of the intimate partner or child, or by its terms explicitly prohibits the use, attempted use, or threatened use of physical force against the intimate partner or child that would reasonably be expected to cause bodily injury. And I have the or in all capitals. Capital letters, because more often than not, the section after the or is what you're going to run into, because so many times with these orders, you have consent orders that come in with no finding of fact. So your or is generally going to be Is going to be on that second section after the or. So as you noticed when I was going through 18 USC 922 G8, I didn't mention anything about it stating in the order not to have a firearm or not to have ammunition. And that's the way it's written. So what types of orders apply? It's any, and I cannot stress it, any criminal or civil order, any. So that could be a probationary judgment where they're on probation after being convicted for some type of domestic assault, and you have a probationary judgment that says not to assault, threaten, abuse, follow, harass. It could be pretrial release conditions, bond conditions. I have the term 50B and 50C. That's kind of North Carolina jargon, but basically it's those protections, or it could be a no contact order with no arrest relief that's ordered. It's essentially just a civil restraining order that doesn't necessarily have arrest authority. A Rule 65, which is another type of restraining order here in North Carolina, or a divorce decree, or child custody. We can go on and on and on. Now I place this here because, you know, you all, or a lot of you all, are in Texas, and you got the Rahimi case. And I just want to kind of give you an update on this. There were oral arguments in this were held Tuesday, November 7th of last year, and decision will likely be issued in June or July of this year. I listened to it online, the Supreme Court case, when it was going on live, and it was really, I enjoyed listening to it because you learned a lot about how the Supreme Court works. It was nice to see this navigating through. So, but again, when we talk about the Rahimi case, it only applies to the Fifth Circuit, which is Louisiana, Mississippi, and Texas, and it only applies not to your state law, it applies to the federal law. So your state law in Texas, if it says you can't possess a gun, then you can't possess a gun. And you can almost, and I know from my time in Texas over the years, you can almost take your state statute dealing with protective orders and firearms and lay it right on top of 18 USC 922 G8, and it's almost identical. The difference here with Rahimi is you can only leverage your state statute, not the federal. Again, it's under appeal, and I've given you the updates, and we'll see where that shakes out mid 2024 or somewhere thereabout. So I want to give you, I'm a visual learner. So I want to show you just some of the orders, and this is what especially my current position as chief deputy, really, really worries me. And I'll show you. Here are some examples. So here's a more current protective order, what they look like today. So obviously, that is a prohibition. I mean, it has what we need on it, but here's some you may not be aware of. Probation judgment. So as long as they have that term, which is right here, shall not assault, threaten, abuse, harass, and they fit the relationship code, that would fit as a federal disqualifier. Here's a bond or bail or pretrial release condition. Not sure what language you use within your jurisdiction, but you know, if we look right here, it says the defendant shall not possess any firearms or other dangerous or deadly weapons. Now, if they were found in possession of those, I have a state statute that I can use. But that in and of itself, just that one term is not a violation of the federal law. The defendant will not assault, threaten, abuse, follow, harass is the element under 18 USC 922. So that's what prompts the federal prohibition there, is that language. So long as they have the relationship that is cited in 18 USC 922 G8. I didn't mention this on the list, but here's a child custody order. Defendant shall not assault, threaten, follow, harass, or interfere with the plaintiff. Again, that touches the statute and what you need for the prohibition. Here's a Rule 65, basically a restraining order that does not have arrest provisions in it if it's violated. But again, it's civil restraining order. Says the defendant shall not assault, threaten, abuse, follow, harass. Now, you can't read this, I don't imagine. That's kind of how judges write, but I'll interpret it for you. All guns / firearms shall be returned to the defendant. So that's an order that came through, signed by the judge. You had due process. Folks were there. I had an opportunity to participate. We cannot give it back. It violates the federal law. And a district court judge or a superior court judge can't force me or this office to violate federal law. Okay, so especially when there's a punitive sentence if you were convicted of it. So although we get these from time to time, it's generally drafted long before it goes to the judge, and they'll approach the bench, both counsel, and say, Judge, we've worked this out. We want to speed it through court. Everybody's agreeable. It's a consent order. Do you mind signing it? And they'll sign it. Well, sometimes judges don't get to read the whole thing. They don't know the history. So I kind of look at us with the sheriff's office as the gatekeeper. We're the safety net. So when that comes to release, we have our own internal policies and practice that makes it very difficult for an order like this to slip through, and we end up transferring a gun to a prohibited individual. And also keep in mind, if we did that, we as members of this office would be violating the federal law. So what type of notice? Well, it's preferred, although not legally required, for defendants to receive notice of the prohibition under 18 USC 922 G8 and G9. And a lot of times that's done on the state protective order forms, at least it is on North Carolina. And I've seen a ton of other states that do the same thing. So they're getting notice in writing on those orders. So go a little bit further, and I told you when early on we were setting up this presentation that a lot of different subsections under 18 USC 922. So how about transferring? This is where I was referencing us under that Rule 65, releasing the gun to a federally prohibited individual. That comes by way of 18 USC 922 D8. It's illegal to transfer a firearm to a person knowing or having reasonable cause to believe that such person is subject to a court order that restrains him or her from harassing, stalking, or threatening an intimate partner. So again, we flip over and look. That's for people with protective orders. It's also illegal to transfer a firearm to a person knowing or having reasonable cause to believe that such person has been convicted in any court of a misdemeanor crime of domestic violence. Proof concerning knowledge on the part of the supplier may be difficult to establish unless the purchaser acknowledges the firearm application that he or she is prohibited. But again, from an investigative standpoint, I would say if we're the ones that are releasing it, we wouldn't have much to stand on in arguing that. It would just be not good for anybody. And we don't want to incur any liability within our agency. All right, so let's switch gears and let's talk about individuals. How do we handle? So we can't just keep endlessly taking in firearms and ammunition. You're going to run out of space, and that is an accurate statement. You certainly can. So a lot of times what happens when a person becomes federally prohibited, those firearms are transferred to someone who is not federally prohibited. All right, John. Well, I remember what you said early on, that when y'all stopped the practice of just seizing guns without direction of the court, you were giving them to third parties and they were giving them back. That is true. And that's why we came up with a notice to third parties. And in this notice, we explain what the state and federal disqualifiers are. Back when we were a purchase permit, if it was a pistol, not only would we run a record check here, they would still have to go through the purchase permit process. Once we implemented this Word document right here, that's just a couple of paragraphs, the number of firearms that left our office and returned to the hands of a disqualified individual went to next to zero. Because what they're doing, we keep this form, we explain to them that they could be in prison for up to 10 years and fined up to $250,000 if they allowed the defendant to have access or possession of that firearm or ammunition. And again, it's signed and witnessed it, and we keep a copy. So most folks, when they have that knowledge, are going to comply. I'm not going to say 100%, but most folks would, because there we have the knowledge. We've already laid out all the elements, hopefully to mitigate any future transfer to a prohibited individual. Again, knowledge is power, and that's not just for those of us that work within the criminal justice system. It's for the people we serve as well. So I'll give you a few more US codes. We got about 20 minutes left, and I've got a ton of slides to go through. Felons with guns, 18 USC 922 D1. It prohibits the possession of a firearm or ammunition by any person who's under the indictment for has been convicted in any court of a crime punishable by imprisonment of a term exceeding 1 year. You notice it doesn't say felony. It hinges upon a term exceeding 1 year. Then they fall under this federal code. So again, I put in here on this last bullet and the reason for it about the firearm being in their home. At one point in North Carolina, believe it or not, this was some years back, and we worked to have this loophole closed. If you were a felon in North Carolina under the state law, you could possess a long gun, a rifle or shotgun anywhere, anytime, was not a crime under state law. And you could possess a pistol within your home. This is a felon now. Again, that did not parallel federal law, and it bumped heads. So we worked with the legislature, and that got changed. So our felon with guns kind of mirrors what the federal code is now. Again, penalties, especially for section 922G, is up to 10 years, up to a $250,000 fine. But again, the additional firearm statutes, as I mentioned earlier, there is a ton, and we only have 90 minutes today to go through them. I'm going to give you a quick rundown of some of the other ones. Fugitive from justice, fled any state to avoid being prosecuted, 18 USC 922 G2. Drug user, addict. So if we have somebody that we have a history, and we don't have to have a conviction, we have a history of drug use through our police reports. That's a disqualifier there, 922 G3. Then you move on to 18 USC 922 G5, non-immigrant visa holders, aliens. There's a prohibition there. And persons that were dishonorably discharged from the military, 18 USC 922 G6. Persons who formally or officially renounce their citizenship, 18 USC 922 G7. And again, we don't have time to go through each and every US code. I mean, the book is yay thick and a ton of different US codes there. The point of the presentation today is to stimulate thought, conversations about this, instead of saying, we're just going to kick the can, it's not our job. I realize that, but if we don't all work together, you notice how the presentation opened with all the statistics. We're going to lose a lot more folks across this country if something isn't done. Again, not anti-gun, but certainly anti-bad folks having them. And there's been so much research to date on lethality indicators. I mean, we have as close to a crystal ball as we've ever had in this profession today. So again, knowledge is power. 18 USC 922 U as in union prohibits stealing or unlawfully taking away firearms from a business inventory of a federal firearm licensee. 18 USC 922K prohibits the transport, ship, receiving, or possession of a firearm with the manufacturer's serial number obliterated, removed, or altered. All different things that we can leverage out there. And again, this presentation today is under the umbrella of domestic violence and intimate partner violence, but we in this business as local law enforcement or state law enforcement have so much interaction with so many different people. And I can't help but wonder how many of people that are federally prohibited slip through the cracks just from sheer lack of knowledge. I know beyond a shadow of a doubt, it's not through malicious intent. We just don't know what we don't know. So where is the vehicle to increase training and knowledge of this? Again, please keep in mind and don't forget that subsections 1 through 9 under 18 USC 922 that prohibits individuals from unlawfully possessing firearms or ammunition are mirrored under the D subsection. So everywhere it's federally prohibited, almost everywhere it's federally prohibited for an individual to possess a firearm or ammunition. It's also federally prohibited to transfer a firearm or ammunition to that individual. So as we're winding down, I want to talk a little bit about investigations dealing with firearms. We know that if it's a violation of state law, it's really easy. Law enforcement with jurisdiction will make the arrest or they'll obtain a warrant. That's the easy part, but this is where we work to. If there's a violation of federal law, we absolutely can draft a report and forward it to the ATF. They may or may not pick it up. Again, look at their staffing. I know we're stretched thin, but I would submit to everyone on this attending this training today, they're probably stretched a little thinner once you really know the numbers and their responsibilities. So it's got to be tough on them, and they certainly have to prioritize things. But we know that as local law enforcement, if it's a federal violation of the law, they're federally prohibited. We actually can do the seizure within, the protections of the Fourth Amendment lawfully. And we can hold that firearm until either if it was their prohibition was because of a pending case is adjudicated and dismissed, or if it's a criminal case that they're already prohibited from possessing, it's held till either there's a transfer or we get an order from a court for destruction. If that comes about, and the overwhelming majority get transferred, and they get transferred to people that are not. I mean, they're just not prohibited. Again, if we seized or they surrendered, which is the better or the right word to use with our protective orders, if a defendant surrenders a firearm pursuant to the protective order, and let's say before that's adjudicated, the companion criminal case, they're convicted for domestic assault, then they're federally prohibited. Even if the order that we used that compelled them to surrender the gun is dismissed, they're still federally disqualified, so we can't give it to them. So again, we have internal checks and balances there. So final thoughts as I'm winding down here. Requests from NICS as evidence. And you heard in one of the first videos I played for you, is talking about 10,000 a year on average come in and lie on the federal forms. This is going to be one of two final thoughts here. We get contacted by NICS a lot of times, and the feds have taken the hits as far as liability goes, but I'm not too sure a lot of that doesn't rest on the shoulders of our local law enforcement agencies. And I'll give you my reason for saying that is this. This is a NICS notification. So this comes from Clarksburg, West Virginia. And they give us some names, some nicknames the person goes by. And basically they ask, does this charge here constitute a federal prohibition? We have 3 business days to respond to that. If we don't respond, and it's what's called a delayed denial, the sale will proceed. So if we wait to day 4, day 5, potentially, and don't respond to this NICS notification, the sale could go on. And to put it into a little more context, I generally put this up and I ask the attendees, do you know what this is? Have you ever seen it? Well, this is a NICS notification that comes through our computer systems that our telecommunicators sit through. And this would be somebody that walked into a federally licensed gun dealer and tried to buy a gun while subject to a protective order. This would pop up on our terminal if it's in our jurisdiction and says, hey, Joe Smith is here at this store. He's trying to buy a gun. We show there's a protective order. Go arrest him, basically. How many times has this happened? You heard how many times they lie on forms and all that, or attempt to buy while subject to protective orders from the federal level. I'll show you North Carolina. Now, granted, this information is super old, and I'll get to the rest of the story, as Paul Harvey used to say, in just a minute. 2002, there were 168 people in the state of North Carolina who walked into a federally licensed gun dealer and attempted to buy a gun while subject to a protective order, thus federally disqualified. 2003, you see 140. Now, I do need to point something out real quick. The law changed in 2003, December 1st. So what I'm using here for 168 is different for 2003. So if you carried it over, if you were doing apples to apples, it maintained 160 to 170 a year for years. Let me ask you this, and you can put this in the chat. So this is 168 people that committed a felony under North Carolina law. I'm not even talking about federal law here. It was a felony offense. It's like a seatbelt ticket on steroids. How many do you think individuals were charged out of those 168 in North Carolina? And keep in mind, they got this saying it's a federal violation. Go lock them up. If y'all don't mind, throw those in the chat. I'd just like to see what you think. Oh, good guesses. All right, y'all are really, yep, somebody got it. Sarah got it. So in 2002, there were two charged. That means 166 weren't. Now, two parts of that story. These sales didn't proceed. They were stopped because NICS knew there was a valid protective order. But we also didn't hold them to account, the people that committed that crime, because they would have known it was illegal to do. So why is it only two? Well, nobody knew about this. Nobody had been trained internally. So what we found is these, and by the way, those two were both in Pitt County in 2002. What I'm not showing you, because I put together the presentation, I'm not going to do that, is 2001, 2000, 1999, where nobody was charged. Again, you don't know what you don't know. Those two we had that year were the only two we had that year, and they were both charged. So again, we get out, we do some training. It increased to 5 in 2003 because we'd done some training in other locations and they called them. But again, you don't know what you don't know. And that applies to cops, advocates, and telecommunicators, or somebody staffing the terminal where the NICS checks comes in. So that's why training is so critically important. Again, a lot of data out there. Here's an article I'm showing. They interviewed the ATF and said, hey, we want updated numbers on this. What is it? And they don't give them anymore. It's not publicly available. And I put a little shout out to one of our local researchers here at our East Carolina University, because she gives me a hard time about using old data. But as I told her, you can't get it anymore. That's why the data's old. I can't make a public record request and get it, but I bet $1 to a hole in the donut, it ain't changed much. So I'm going to provide some real world examples as I'm coming to a close here in a minute around the country where law enforcement comes into contact with firearms. Some of this is domestic violence, but a lot of it isn't. You know, I can tell you, and this comes from our local paper, 91% of the firearms that we come across are stolen, and they come from unlocked vehicles. So we're recovering these, but was it stolen from a prohibited individual? You know, so that's one way we'll come in with firearms. Right here, meth and stolen gun found during traffic stop. So this isn't a domestic violence case. It's just through our course of tour of duty, we're going to come across guns. So 2 arrested here in Michigan, weapons, ammunition, after hearing a shots fired call, right? All these guns come into the office, and a lot of times we can track down through a trace who these guns belong to, because most of these are stolen. So when the owner comes up and we identify them, hey, we've recovered your gun. They own the property they're coming up, which is my 2 of 2 final thoughts. Make sure, as the law enforcement agency that has custody of that item, of the firearms, that we're running record checks. Just merely being able to prove they're the owner does not mean they're not prohibited. So if we're not doing really good and thorough record checks, I can see where guns go to prohibited individuals, which brings me to the potential liability. I made reference just a minute ago about the feds taking the hit in federal liability, and I'm going to show you a few. Here you go, the Charleston loophole, right here. Dylan Roof, when he was able to purchase the gun, killed 9 people at the Charleston church in 2015. Again, went through a record check. Settlement, $88 million. These are settlements now with the federal government, 88 million. Parkland, here's another settlement, 130 million. Sutherland Springs, 230 million. Is what they were ordered. It ended up getting cut down to 144 and a half. But my point is, going back to like the NICS checks and the notifications, I can't help but wonder how many of these NICS checks that come through that we don't act upon, or we don't, and it's subsequently a sale goes on either then or later when we had an opportunity to intervene, you have another mass shooting. It really worries me. And in my, again, current position as chief deputy, I mean, I worry at a significant level about this because we haven't done a lot of comprehensive training across the board on this issue. Again, we're focusing on domestic violence, but keep in mind that the white book is really, really thick and there are a lot of different things in there. So I just want to recap a few things that I think are really important going forward across the country is this. We need to increase the knowledge of what law enforcement, telecommunicators, and record staff can do. I mean, if they have a knowledge of what the prohibitors are and they see it, hopefully we can mitigate transfers in the future. We've got to know our state law, but our federal law, and also search and seizure. All this stuff is bound together. As John Stewart said in the video I played initially, is this going to solve everything? No, but it certainly is a good start if we, knowing what we know now with the data that's been shared, and I've shared some of that with you today, it's certainly a good place to start. So I'm winding down about 3 minutes ahead of schedule. I appreciate those of you that have attended today. I guess I can take a couple questions if they are in the chat, or if y'all want to put them in there, Lacey can send those some and I can respond with her and try to answer any questions you may have. But again, keep in mind, this is really a thumbnail sketch. It's what I could give you within a 90-minute time frame today. So I hope the information you saw today at least stimulates thought and maybe positive changes in the future within the communities you all serve. So any questions before we close it out? I think we have.
Yes. Oh, there was one in the chat, and this was towards the beginning, but it says, what is the answer to law enforcement saying they don't have the ability to monitor firearm forfeiture, nor anything they can do with the firearms if they were to forfeit directly to law enforcement?
Well, again, I'll go back to the slide where I talked about when we implemented our change locally about drafting reports. You have a record now. And I'll kind of parallel that by saying this. In our business, we answer initial call. We assign supervisors, will assign some of those cases for follow-up. Our parallel here is like domestic violence. We do not close our cases within our record management system until the case is adjudicated. Why do we keep it open that long? Well, we know through the research how much witness intimidation is occurring. So we keep it open till then. And we may have every member of our domestic violence unit, because they work different shifts, working on the same case. So is it extremely difficult? No, I don't think so, because if it was, we probably wouldn't be able to do it. But it is a commitment to change the way we've done in the past. A couple sayings: if you always do what you've always done, you always get what you've always gotten. Definition of insanity, right? Doing the same thing over and over and over again, expecting different results. Where there's a will, there's a way. every failure within our system can be tracked to one of two things. This is my opinion: lack of training, lack of communication. So I really believe if we become more vested in making a difference, we can do it. We can't do it on our own. There's got to be a collective group. None of this started just with the office of the sheriff. It was done in conjunction with the judges and the advocates in the community. So again, baby steps. Doing a little bit of something is better than a lot of nothing. So I really have enjoyed my time today. Thank you all for attending.
Thank you so much, John. I really appreciate it. It looks like getting a lot of great feedback in the chat. So thank you for joining us today. And thanks, John, again, for your expertise. I learned a lot today. I know other people did as well. Please don't hesitate to reach out to John. I can say, as someone that knows him, that he really wants to help and will try his best to get the answers to you. Please join us for our next monthly webinar next month. We're going to hear from Ken Shetter, who's the National Director of the Family Justice Center Alliance, and he is going to be discussing rural family justice centers, and I believe bringing on some directors from actual rural communities that have successfully established family justice centers. So we're excited to hear what he has to say. And then we are super excited that we just recently announced our keynote speaker for the Conference on Crimes Against Women coming up in a couple months. It's our favorite time of year in Dallas. John will be there along with lots of other great folks. And so our keynote this year is Tony Porter, who is with a chief executive officer with A Call to Men, and then Kimya Motley, who is a survivor and also the chief communications officer. And they are going to do a unique kind of conversation as a keynote. So we're super excited about that and know that we'll get lots of great information from them. So registration is open and early bird pricing ends tomorrow. So hurry up and get that early bird pricing so that you can attend with us. And then one other thing, we launched our National Training Center on Crimes Against Women, and we have launched now the website. So go and visit trainingsaw.org to find some of the upcoming trainings that we're going to be having. Now that we have the National Training Center, we're able to expand our programming to year-round programming, not just the 3.5 days at the conference. And it allows us really to dive deeper into some more discipline-specific programs. So we are super excited about that and want you to check out the website for upcoming trainings. And then we just thank you so much for joining us. At the end of when you close out of your Zoom, your browser should open up with a survey that will populate, and that will give you after you complete the survey, that will give you your certificate that you can print out for your records. So a recording of today's presentation is going to be available on the ICCR website, hopefully by the end of tomorrow, along with a copy of John's PowerPoint presentation. And we hope everyone has a great day. Thank you.
Thank you, Lacey.
Thank you.